Hello there and welcome once again to The Verdict. Mick Cornett with Kent Meyers. We're here every week, meeting interesting people and dealing with topical issues. And today we're going to get an update on everything in front of the Supreme Court.
Well, everything of note we're going to get
true.
in front of the Supreme Court. Yes, we're going to have Professor Joseph Tye from the University of Oklahoma College of Law join us and talk about the major issues that he sees the Supreme Court's dealing with, and we'll get him out on a limb and then get him to predict how it's going to come out. But we have four different matters we want to talk to him about.
Student debt, affirmative action, and some others. So
Yep.
Stick around. You're watching The Verdict, and we'll be right back.
Right now, 6 feet can feel like a long ways away. But from 6 feet, we can still smile at each other. From our doorways and our stairways, from opposite sides of the street and opposite sides of the country. Through fear and frustrations, we can remind each other that we are still here for each other. Because we can still smile at each other. And we're not going anywhere.
Military service ran in my blood, starting from my father, which joined the Navy, on the Chickasaw side, my uncle, which served in the United States Army. I'm Benjamin Espinosa, Chief Petty Officer, United States Navy, and I'm Chickasaw. I went to the Secretary of Defense's staff at the Pentagon in Washington, D.C., which ultimately led to becoming a combat support technician for Naval Special Warfare, specifically SEAL Team 10. I think to be proud and to love your tribe, to love being Chickasaw, you also have to love being American. You also have to love everything that America stands for. Equality, perseverance, professionalism, and power. I want my family to know that their father is a good person, but also feels that he has an obligation to the country and to love this nation. Anything worth having is worth dying for. The military and the country owes me nothing. I owe it everything.
See more stories about the Chickasaw people at profilesofanation.com.
Welcome back to the set of The Verdict. Mick Cornett with Kent Meyers. Kent's going to introduce today's guest.
Today our guest is Professor Joseph Tye from the University of Oklahoma College of Law. Joe did his undergraduate work at Harvard College, did his law work at Harvard Law School. He was a law clerk to Justice John Paul Stevens, Justice Byron White, and then at the circuit level, Justice David E. Bell. He has a niche in the Supreme Court area that few are able to command by virtue of his practical experience as well as his studies, and that's the courses that he teaches at OU. He's been the recipient of many awards from the university and elsewhere, and he is our go-to guest on Supreme Court matters. Joe, sure, glad to have you, and welcome back.
It's always an honor to be here, and this is such a valuable forum for civil discussion, so I appreciate the opportunity.
We're going to jump right into the debt forgiveness situation. So the Biden administration is hoping to reduce the student debt to millions of Americans, mostly young Americans, but Americans.
That's right.
What are we talking about here in the grand scheme of things?
Well, in terms of size, it's about $500 million worth of student debt that are owed by more than 40 million Americans. And so the Biden administration wants to wipe out that debt up to 10,000 or 20,000, depending on eligibility requirements. But the big legal issue is when Congress passes a law that grants general authority to the president, like in this case, to waive or modify any student loan law, can the president go big and not just waive and modify, but just wipe out? And that has big consequences beyond student debt.
Well, if waive and modify are the operative words, wiping out doesn't seem to be in normal discourse included in that.
Well, you know, there are arguments on each side, and that's the argument that some of the justices and the challengers have made, which is waiving and modifying means just that, you know, you can tinker with the program but not wipe away the entire program. And President Trump and Biden have both used that language to delay the repayment of federal student debt. But the question is, can Biden go big? And this has consequences in the future for other types of statutes that give presidents power to do things like, for example, enforce immigration laws. So suppose we have a President DeSantis in 4 years wanting to go big on immigration enforcement. If the Supreme Court says, no, you got to get a clear statement of authorization from Congress before you can go big on a regulation, then that can affect both Republican and Democratic presidents.
So what the court is looking at is it's not the economics, it's not really looking at the fairness, it's looking at presidential authority in this time of emergency, which the president reached into his job description and decided he could do.
That's absolutely right. So there's the political arguments about fairness of wiping out student debt, but what the Supreme Court is looking at is power. Can Congress grant broad power to the president, and then can the president exploit that power, maybe in ways that Congress didn't even imagine? And of course, that would affect the ability of the presidents in the White House, Republican and Democratic, to carry out their policy priorities.
Okay, how do you think it's going to turn out?
Oh, I think that the bets are that Biden's going to lose and the debt won't be wiped out because the justices, probably by a vote of 5 or 4, if not 6-3, are going to say presidents need a clear statement from Congress before they can enact policies that have vast and broad economic and political consequences.
All right, let's switch to affirmative action. Harvard and UNC, North Carolina, are involved in a case involving affirmative action. This seems like an old topic. What's new here?
Well, what's new is now we have a majority of conservative justices who are very skeptical of race-conscious affirmative action. And so the issue is, can public universities and private universities that take federal funding, can they use race as one factor among many when considering whether to admit a student to create a diverse student body?
And in this case, Harvard and University of North Carolina, along with no others, are wanting to be able to consider it.
That's right. What schools like Harvard and North Carolina argue is that, hey, look, we're a diverse society, we're a pipeline to leadership in our society, and having a diverse student body helps to educate them and train them to be leaders in our society. And we need to consider all sorts of diversity. Do we have enough people from rural areas in addition to urban areas? Do we have enough people who come from military backgrounds versus people who come from different backgrounds? And do we have enough people across the racial spectrum so we can get all views? So that's the argument on the side of the universities. On the other side is the argument when you start to consider an applicant's race and you say that this applicant's race is a plus factor in admitting them, then that harms other students of other races potentially. And these cases are brought by Asian American and white plaintiffs who claim that they're harmed by these affirmative action programs.
Prediction time. How do you predict this one will come out?
Well, this is too easy because we've already heard the oral arguments. And so the sentiment among the justices, and I think it's at least 5-4 again, if not 6-3, is that the Supreme Court's going to say no use of race at all is permissible in affirmative action programs, that violates both the Constitution and federal law.
Well, is this carried to its logical extreme then? If that were the decision of the court, would that mean that you couldn't even ask an applicant in an application for admission, what race are they?
That's right. So you won't have the box to check as to what race you identify with. But what some of the justices seemed okay with is someone in an essay saying, you know what, I'm a black student. I grew up in the South in a place where I had to overcome a lot of discrimination. Some of the justices would say, well, but that's okay because it's not really about their race. It's about the challenges that they face given their background, and it shows their character. And so you would force universities to look at each applicant as an individual without considering more broadly what race do they belong to.
Now, what have states done on their own prior to this case, if anything?
Well, gosh, you have big states like California, and then you have other states like Michigan and Oklahoma banning the use of race in admissions by voter initiatives. And so at OU, for example, for more than a decade, because of the voter referendum, we don't actually consider race in admissions. Instead, we consider race-neutral factors in trying to create a diverse class, like socioeconomic factors, GPA, test scores, essays, and things like that.
And race-neutral factors, if the Supreme Court comes down against the universities, would still remain permissible?
That's right. In fact, it would be the preferred way to go about building a diverse class, to look at applicants without considering their race in order to create a diverse class. But I think it's still okay, even in that world, to look to see if you actually do have a diverse class. And if you don't, maybe you can go out and try to recruit a diverse student body without actually considering race when you get to the admissions process.
How do historical black colleges and universities deal with this decision?
Well, that's a great question. They would be bound by it. So HBCUs would also not be able to consider whether an applicant is African American or not, but they would still be allowed, I think, to go out and recruit that in that population to ensure that they preserve sort of the historical character of their HBCU legacy.
Well, am I oversimplifying it? If the Supreme Court were to say you can't do it, that would have little or no impact in Oklahoma?
No, you're not simplifying it at all. At least in the states like Oklahoma, where we've already outlawed the use of race in admissions, that wouldn't have an effect. But most states across the union don't have those laws. And so in most universities across the country, they still consider race as one of several factors in admissions. And so this would be a sweeping decision if they outlawed it.
If we had President Harris from the University of Oklahoma here under oath and ask him, has he, in his administration, without the ability to do this, created a diverse university, I suspect he'd say, yeah, we have.
Well, we've devoted a lot of resources to recruit students, not only just all over the state, but all over the region, all over the country, to ensure a diverse student body, and so that we can offer the best education that we can. And so it's just going to take a lot more time and effort and money.
All right, let's get to a break. We're visiting with Joseph Tighe, and we're talking about several issues that are in front of the Supreme Court currently. We have more to come on the other side of this break, so stay with us.
At Whitten Burridge, we're litigators. That's all we do. All of our clients, some sort of wrong has occurred to them. We try to right that wrong. Corporate America, they have all the power. It's sort of like going against an army. I like helping the underdog. That's what gets me up out of bed every day.
Our success rate is phenomenal, but that's not all they get. We care about people.
I'm very proud of what we've been able to do for our clients, and I'm looking forward to what we're going to do in the future. There's still a lot of wrongs that need to be righted.
OU Law has a history and heritage that are unparalleled. At the University of Oklahoma College of Law, we empower our students to pursue the career of their dreams. We have the highest U.S. News ranking ever achieved by an Oklahoma law school. We are the first law school in the country to launch a college-wide digital initiative. And this year, our competition teams ranked #2 in the nation. OU Law, generations of excellence, limitless possibilities.
One of the best kept secrets about the post 9/11 GI Bill benefit is that it can be used at a trade school or a technical school, and it doesn't have to be used at a university or college. These are benefits that the veterans have earned through their service, and they should take advantage of it.
Veterans really need to understand that there are many resources offered by the Oklahoma Department of Veteran Affairs. They are there to help you find the right school for you, the school that will help you and your family make great steps into your future.
Welcome back to the set of The Verdict. Mick Cornett with Kent Meyers, and Kent's going to continue our discussion with Joseph Tighe on the Supreme Court.
Joe, an issue that we want to get to now is the Dobbs/Roe v. Wade issue that's been decided by the Supreme Court overruling Roe v. Wade. Can you talk to our viewers about that on the issues? We also want to talk to you, when you're ready to talk about it, about the leak of the Dobbs opinion that has been investigated and has been in the news. Now, Roe v. Wade has been overruled. We know that. Let's talk a little bit about why that was so.
Well, at war are two different ways to read the Constitution. So for the justices who overruled Roe v. Wade, they want to read the Constitution the way that they think it was originally intended. And so what they argued was that in the 18th and 19th century, abortion was actually a crime. And so the Constitution did not protect a right for a woman to make that decision to terminate her pregnancy. On the other side, the dissenters who would support Roe v. Wade said, well, look, the Constitution protects liberty, and we need to read the word liberty in modern terms, and we understand in modern terms that liberty includes the right of women to make reproductive choices. So those were the two warring ways to read the Constitution that ended up resulting in a 5-4 decision to overrule Roe v. Wade. So that's the legal merits of the decision, as we lawyers say, or what was the legal issue that was decided.
Okay, and then there was a leak early on in this case that the cable talk shows loved. But it was really, if not unprecedented, a very rare occurrence of information leaking out.
Oh yes, there had been leaks from the Supreme Court over time, including the Dred Scott decision before the Civil War, but those have been mainly leaks about the result. Here we had the entire draft opinion being leaked to the press 2 months before the actual decision in early May, and the decision was in late June. And I actually happened to be at the court on the day that the opinion was leaked, sitting in front of the justices for a memorial ceremony for my old boss, Justice Stevens. And we were all just kind of noticing how somber the justices were, including especially Justice Alito, who ended up writing the majority opinion that was leaked. And we were just asking ourselves, is there something going on? Is Justice Alito always this dour? And our conclusion was, well, yeah, maybe, probably. He's just aged, and so he looks a little bit more somber. But it turned out it was because they already knew that this was going to hit the press.
Mm-hmm. And so, how does that happen? I mean, and is there do they investigate it? Are there repercussions to this? Do they know who did it? I mean.
Well, it's a great question, and the court hasn't answered it, right? And so you look at two things for who done it. Like you look at opportunity and motive, right? So opportunity, who had the draft opinions? The justices themselves, and if they took them home, then also their family members. All the law clerks working on the opinions, and each justice has 4 law clerks. Even the janitors who would have access to drafts that were laying around inside the court. So it's a pretty big universe.
Dozens of people suddenly.
Dozens of people, yeah. Yeah.
Was there any attempt to, prior to the leak, to keep those drafts protected in any secure way?
Oh, yes. I mean, they have separate computers that they work on so that they're not networked, so they can't be hacked. As far as physical drafts, you have burn bags that you're supposed to drop them in so that they can be burned when you move on to the next draft. And what happened after the leak was that the Chief Justice ordered the marshal to conduct an internal investigation, and they had law clerks under oath being interrogated on the record. It was recorded. They had staff being interrogated on the record. It was recorded. And they had the justices being interviewed. But those interviews weren't recorded, and they required the staff and the law clerks to sign affidavits under penalty of perjury that they were telling the truth, but they didn't require the justices to do that. And so there's been a lot of criticism that they didn't fully investigate the justices themselves.
Well, who would have had something to gain from this?
Gosh, this is what makes it really interesting, because both sides arguably had something to gain. By leaking the opinion ahead of time, if you were a supporter of Roe v. Wade, you would be counting on the public backlash,
right,
to maybe move some justices who are sitting on the fence to decide not to overrule Roe v. Wade. But the argument is, if you want to overrule Roe v. Wade, then you want to leak it so that the justices on the fence would harden their views to overrule Roe v. Wade, because otherwise it would look like they're weak-willed, they have a weak spine, and they're being swayed by public pressure, and no justice wants to give off that impression of being weak.
Well, you served as a clerk to 2 Supreme Court justices.
That's right.
Did you ever have any leak situation in your?
Not that I am aware of, and you know, we actually had Bush v. Gore.
You realize you're under oath here.
Or at least I'm on the tape. Bush v. Gore was decided during our term, and I remember journalists trying to catch us and interview us on our way in to work on the cases. But you know, I had all of my stuff, you know, under my coat.
All right, switching topics slightly here. They're discussing term limits for the court. What is that about?
Well, you know, this is not just a backlash against Dobbs and the overruling of Roe v. Wade, but there's a sense that the justices end up sticking on the court for too long and becoming too powerful, and it's good to have some turnover so that the justices reflect more the current sentiments of the country. And so there's been a movement to reform the court, including to mandate retirement age. But I don't think that is going to be possible because the Constitution grants life tenure to the justices. And so I think the justices would say that this would violate their life tenure.
Couldn't you say the same thing about age limits? Because that's not in the Constitution.
Right. So the funny thing about Supreme Court justices is that there's no requirement in the Constitution that they be of a certain age, unlike presidents.
So a middle school person could technically, theoretically, constitutionally, be put into a Supreme Court position.
Yeah, absolutely. Yeah. There's also no citizenship requirement or a requirement that they be lawyers. And so you can have a Canadian middle school student.
It couldn't be more broad, could it?
No, it couldn't. But of course, you got to be nominated by the president and confirmed by the Senate. So there's a political check on that.
And court packing.
Oh, court packing. Well, you know, there's nothing new under the sun. Of course, in the aftermath of overruling Roe v. Wade, critics of the court say we need a bigger court in order to allow President Biden to pack it.
Now, see, I assumed, we talked before, that there's not a number. I just thought the number of Supreme Court justices was in the Constitution. I'm surprised to hear it's not.
No, it's not. The Constitution only requires that there shall be a Supreme Court, but doesn't specify the number. And so the number has varied in the 200 plus years of Supreme Court history, including when President Jefferson won election in the year 1800, the Federalists, the losing party, decreased the number of justices from 6 to 5, so he wouldn't be able to appoint the 6th to fill that spot. And when Lincoln was assassinated, the number of justices was 10, and the radical Republicans reduced it to 9, so that Andrew Johnson, who they felt was too soft on the South, could not appoint a 10th, and so it and so hardened that it's unlikely that in the current climate, Congress would be able to amend the federal law to increase or decrease the number of justices. But I've been a fan of increasing the court to maybe 12 or 15 so that we don't have these hardened factions on the left and right, but we'd have enough people that there'd be compromises, more compromises at least.
What would it take to get that done?
It would just take another federal law that would change the number of justices, and so it would take the Congress and the president agreeing, which these days is a pretty hard task.
Yeah, so it would just be like any other law, but there's no constitutional change necessary.
No, not like forcing the justices to retire. They could change the numbers at will.
What do your students think about all these things? Are they fascinated by the history of the court and the current issues?
They are, and what they end up realizing is that debate over the Supreme Court has always been part of our politics, and so it's nothing new to attack the court or to seek to change the court. And what I'm really heartened by is that my current students, they want to find a way to reform the court so that it becomes less partisan, less political.
All right. Joe, thanks so much for coming on.
Yeah, thank you. Boy, you covered a lot of ground.
Well, great questions, and it's always a pleasure.
Kent and I'll be back with a final word after this.
This is the epidemic of my generation. This is my HIV. This is my Black Plague.
In the midst of one of our state's largest crises,
Oklahomans are dying from this preventable and treatable disease on a daily basis.
We believe there's hope.
That little pill will cause destruction through your whole life.
Watch the entire award-winning 9-part docuseries Killing Pain, made available by Fighting Addiction Through Education at killingpain.com.
It used to be okay in hospitals. It used to be okay in movie theaters. It was okay in classrooms, restaurants, and airplanes. But thanks to a greater understanding of the dangers, that's not okay anymore. So now that we know secondhand smoke causes lifelong health problems, why is it still okay to smoke with children in the car? Bottom line, it's not okay. Let's get serious about protecting kids. Join the fight at stopswithme.com.
All children deserve a life of hope and love, but sometimes they experience a life of pain, neglect, and abuse.
When that happens, each child deserves all the quality assistance and representation that can be offered in our legal system. For more information, call 23-CHILD.
Oklahoma Lawyers for Children, helping to bring hope and love back to the lives of abused children.
You will always be mom and dad to me.
You have children come from a different lifestyle, different mindset. You have to open your arms and really do what you have to do to have that child become a part of your family. And if it's more patience, that's what you do. Kids gotta know they can trust you. And that's what we try to do with these kids.
You will always be mom and dad to me.
Joseph Ty really good at handling a lot of different subjects in a very short period of time.
Yes, he's able to juggle issues really well without dropping any of them. He is a fine guest, a fine professor, and a good friend to the show and to us, and we appreciate his time.
And we'll be watching to see how the court decides on these cases.
We'll give him a scorecard.
All right. We have some website information. I don't have it here in front of me, but I will shortly. Here it is. You can get more information on the University of Oklahoma's Law School at law.ou.edu. That's law.ou.edu. And we have a website. It's called theverdict.tv, and you can log on there and tell us about a guest you'd like to see or a subject you'd like to see discussed on a future show. We'd love to have you do that. Again, our thanks to Joe for coming on the show, and we'll see you next week with another edition of The Verdict.